About 3 or 4 years ago, they changed the landlord-tenant law in this way, which was there was an ability for a person, if there was a mistake in the filing of an eviction by a landlord, an obvious mistake, that the case would be dismissed and the tenant would immediately be eligible to get their attorney's fees, sometimes multiplied out because it's hard to get an attorney when you're a tenant. And so some of these fees were up in the $5,000 or $6,000 range. Our legislature has met and tried to address that problem. And so we have a new statute, new in the last 2 or 3 years, in which now if there's a mistake in some of the notices that you have to file, and you're the landlord, you get a chance to refile them without having your case dismissed. That's a big deal because it saves you losing the case and therefore paying attorney's fees.
So in the old days, if you made a small mistake within your 3-day notice to pay rent or vacate, the judge would dismiss your case, throw you out of court, and order that you pay your tenant's attorney's fees. These days, they give you an opportunity to fix that mistake.
You have said it exactly right, yes.
So we know that when a tenant does not pay rent, step number one always is a 3-day notice to pay rent or vacate. And if that form is actually given to us by the Florida statutes, and it looks relatively simple to fill out, but you and I know that there's all kinds of mistakes that can be made in it.
Right, and it's interesting you put it that way because I hear that a lot in my workshops, which is how could this be hard to do? The court, or the legislature wrote it for us. If you go down to the court, they give you this form. It's simple. You just fill out a couple of blanks and you're set to jet. But everything about that form, every fill-in that occurs has been litigated time and time again. And we have lots of rules now that nobody would be able to find unless you were a lawyer reading legal cases. So if you don't read those cases, if you have something better to read than legal cases, you're probably going to miss the fact that a 3-day notice, for instance, turns into an 8-day notice if rent is due out of county. It wouldn't be in the statute, wouldn't be on the form. You just wouldn't know that that's what you have to do.
Well, now you're telling me something that I did not know. But if you're telling me that if I have a rental property in Seminole County and yet I'm asking the tenant to bring me rent within 3 days to my home in Orange County, they have 8 days to do it.
That's right. You have to add mailing. I know it sounds kind of ridiculous because you and I know that you could have 1 foot in Seminole County and walk 10 feet and be Orange County. But the way this started was that there were landlords who were up in New York and Washington who were demanding rent. And so over time, the courts have slowly moved that line. First it was New York, Washington, and then it was South Carolina, then Georgia, then northern Florida. And finally they got to a point where they laid down the rule, if it's out of county, you have to add mailing in terms of the timing.
But when you do, as a landlord, you do this 3-day notice to pay rent or vacate, and it is what it sounds like, isn't the expectation that the tenant is going to hand deliver that rent to you?
No, not necessarily. I mean, let's suppose the landlord is up in New York, which is pretty common here in Florida. There's no way that you would expect that would be.
Well, let's say the landlord is in the same city as you are, but let's say on day number 3, rather than the tenant hand delivering the rent to the landlord, on day number 3, the tenant puts the rent in the mail to the landlord.
Right.
In law, when it's in the mail, it's considered to be delivered. Would that be true?
That would not be true. You have to have it. It is as if you walk that check over, and so you literally have it to a stated point in time that's put on the 3-day notice. So you don't just go 3 days or 8 days. You literally list the last moment in time you can make that payment. And however, it didn't matter that you put it in the mail. It needs to be in the landlord's hands by that last moment in time that's in the 3-day notice.
Okay, so in this situation then, it is delivered in the mail is not necessarily delivered. If your landlord is in the same county as you must either deliver it by hand within 3 days or somehow get the mail delivered within 3 days that contains your rent.
That's right.
Okay.
Yep.
All right.
Yep.
Glad to clarify the confusion. Hey, folks, my name is Tom Olson. My guest today is attorney Rob Solomon. He is a landlord-tenant attorney.